Okay, picture this. You're an entrepreneur or a developer, right? And you've got this massive multi-million dollar infrastructure project. Can you just break ground, build the whole thing first, and then kind of just ask for environmental permission later? Well, for years, a build first, ask later workaround seemed to be quietly taking root in India's industrial sector. But a massive legal earthquake just hit that literally rewrites the entire playbook. Welcome to today's Explainer, where we're breaking down a monumental shift in environmental law that every business owner, developer, and focus learner absolutely needs to understand. Our core focus today is this landmark July 2026 Supreme Court ruling on retrospective environmental clearances. A three-judge bench just fundamentally altered how the Ministry of Environment, Forest, and Climate Change handles projects that started without getting a green nod first. The highest court in the land has officially quashed a highly controversial 2021 office memorandum. And the implications here? They are absolutely massive for both the environment and the economy. Okay, let's dive into this. Here is our roadmap for today. 1. The rule of prior approval. 2. The 2021 backdoor memorandum. 3. Supreme Court strikes it down. 4. What happens to existing projects? 5. Next steps for the government. And finally, 6. The bottom line for business. Right, starting off with Section 1, the rule of prior approval. Let's look at how this all built up over time. Back in 1986, the Environment Protection Act laid the initial groundwork. Fast forward a bit to 2006, and the Environmental Impact Assessment, or the EIA notification, made it strictly mandatory to get clearance before you start building. But, over time, the government faced this reality where a lot of industries were just operating without these clearances. So, in 2017, they issued a temporary 6-month amnesty notification to bring violators into compliance. And then, in 2021, the government actually went a step further. They introduced an office memorandum that created a permanent standard operating procedure for dealing with violation cases. Now, just to make sure we're on the same page, we really need to define our central term here, the environmental clearance, or EC. Basically, this is a mandatory approval required under that 2006 EIA notification, and the absolutely critical anchor word here is prior. You have to obtain this approval to ensure a project doesn't irreversibly harm the environment before you even commence any specified large-scale development activities. The whole shebang is built on assessing the impact before the damage is actually done. Section 2, the 2021 backdoor memorandum. So, as we saw on the timeline, theory and practice kind of started to drift apart. We had this fundamental clash of legal approaches. On one hand, the statutory 2006 EIA notification strictly requires a holistic assessment and clearance before any environmental impact occurs. But on the other hand, the 2021 office memorandum issued by the ministry essentially created this perpetual, ongoing regime. It allowed project proponents who had completely bypassed the 2006 rules to step forward, pay a penalty, undergo an assessment, and seek a post-facto green nod after they had already started building or expanding. This excerpt shows the 2021 standard operating procedure detailing exactly how these violation cases were handled. Now, the union government argued that this SOP wasn't a free pass, right? They said it was a practical mechanism to identify violators, assess environmental damage, force them to remediate, and impose some pretty hefty penalties. But environmental groups, most notably the NGO Vanashakti, they saw this very differently. To them, this was a completely illegal backdoor that rewarded violators, disadvantaged the legally compliant businesses, and just totally bypassed the statutory law. Section 3, Supreme Court strikes it down. Now, what's really interesting about this is the exact phrasing used by Justice Joy Mallya Bagchi. He stated, "The 2021 OM is an administrative order. It supplants delegated legislation through an administrative instruction, which is impermissible in law." In simple terms, the government just cannot override a strong statutory law like the 2006 notification with a simple administrative office memo. The legal hierarchy just absolutely does not allow it. So let's break down the constitutional mechanics behind the Supreme Court's ruling. The court found the 2021 OM failed on a few major fronts. First off, it violated Article 14, the right to equality, and Article 21, the right to life. Why? Because it didn't have a logical way to differentiate between projects, which is what the court calls intelligible differentia. It also bypassed the proper statutory amendment process that's required under Section 3 of the Environment Protection Act.
Ultimately, it undermined the precautionary principle, which is this absolute cornerstone of environmental jurisprudence that says, hey, we must act to prevent environmental harm before it happens.
Section 4. What happens to existing projects? Obviously, the moment this ruling was handed down, a massive wave of panic swept through the real estate and infrastructure sectors. I mean, what about the huge projects that already relied on this 2021 OM? And this brilliantly illustrates what we call the doctrine of proportionality. The court had to weigh two incredibly heavy competing interests here, enforcing strict environmental compliance on one side versus causing catastrophic economic destruction on the other. If they strictly nullified every single past clearance, completed hospitals and infrastructure built with thousands of crores of public money would literally have to be demolished. So the court stepped in with some crucial relief. The ruling was given a prospective effect. That means environmental clearances that were already granted under the 2017 and 2021 regimes, they remain valid unless someone comes along and challenges a specific project individually in court. This decision actively recalled an earlier, much harsher May 2025 judgment to prevent the demolition of completed projects, recognizing the massive amount of public resources and employment that were on the line. To put that into perspective, let's ground this legal theory in some real-world examples to see exactly what was saved from the wrecking ball. The Solicitor General pointed out some vital public projects that relied on these retrospective clearances. We're talking about a 960-bed Ames Hospital and Medical College in Odisha, a massive greenfield airport in Vijayanagar, Karnataka, and several common effluent treatment plants, which, ironically, are essential for controlling pollution. Demolishing these would have caused immense public and environmental harm, for sure. Section 5. Next steps for the government. With the immediate crisis for existing projects averted, what is the road ahead for the Ministry of Environment, Forest and Climate Change? Well, the Supreme Court made a really important distinction here. They didn't say the government can never grant a retrospective clearance. Actually, scratch that. It's more like they mandated that the government must use the proper legal front door. First, they can't use these administrative office memos for this anymore. Second, if there is a supervening public interest, they have to draft a narrowly tailored, time-bound amnesty scheme, not a perpetual one that lasts forever. And third, they must issue it as a valid statutory notification under Section 3 of the Environment Protection Act. The power is still there, but the procedure has to be legally airtight. Section 6. The bottom line for business. So the crucial point is, what does this all mean for you? The build first, ask later era is officially over, folks. Going forward, prior environmental clearance is the absolute rule for all new specified projects. You can no longer bank on the 2021 OM for a post-facto regularization if you jump the gun. Now, while your existing clearances are secure for now, attempting to bypass the 2006 EIA notification in the future, that's going to invite severe penalties and, quite possibly, the total closure of your operations. Compliance must be built into your project roadmap from day one, literally before a single shovel hits the dirt. I'll leave you with a final thought to ponder. Will this strict adherence to the rules ultimately foster greener innovation from the ground up, or is it going to pose major new challenges for India's infrastructure boom? What do you think? If you found this update helpful, please hit the like button and share this video with fellow entrepreneurs. For more deep dives into the latest environmental regulations and industrial news, subscribe to our channel and turn on notifications. See you in the next one.